Great.
We have everybody and everybody can hear us and we have quorum.
Very well. The minutes have been forwarded to everyone. Excuse me. Are there any corrections or additions to minutes from our last meeting? Hearing none, I'd entertain a motion to accept the minutes.
So moved.
Motion to.
Second?
Second.
It's been moved and seconded that the minutes from our last meeting be accepted. So ordered.
And so, sorry, because we have so many people on video, we have to do a roll call vote. So folks on video, take yourself off mute. Here we go. Marcus Stallone. I have to say yes. Jim Jacobs.
Yes.
For those of us here, okay.
Cheryl Ingram.
Here.
Do you approve the minutes?
Oh, yes.
Shoba.
Yep.
Joby.
Bye-bye.
Yakov.
Yes.
Latoya.
Yes.
Chief Davis.
Yes.
Ari Jones.
Yes.
Jen Passwater for Ryan Spain.
Representative Spain just joined.
Hey, Jen.
Rep Spain just joined.
Rep Spain just joined.
Okay. Sorry, we're just turning up our volume. Robert Peters.
Yes.
Bob Berlin.
Yes.
Kelly Cassidy.
Yes.
Lisa Daniels.
Yes.
Scott Main.
Yes.
I already got Robert Peters, are you still with us?
I am.
Okay. Are you a yes on the minutes?
I am a yes.
Okay. We have Darren Bailey. Colin, are you on for Darren Bailey? Okay, so they are absent. All right. We have unanimous approval.
Very well. Your minutes will be received. As I indicated, we have an ambitious agenda for this meeting. We have an equally ambitious agenda for the resentencing policies and practices. After reading some of the comments, it occurred to me that one may argue that our approach is heavily written in equity, the concept of equity. And I remember from law school, a professor saying, equity is not necessarily your better argument as it relates to the theory of a case. But then I began to think about some of the examples of where equity has paid out in ACEs. We have award-winning specialty courts, the Veterans Court, the Drug Courts, the Shoplifters Court, are all based in the concept of equity. Before these courts were convened, those defendants, our veterans as an example, many of whom suffered from PTSD, were treated as any other defendant. And it's only after the recognition by the mental health professionals and the court were we able to give some relief, some proper and appropriate and equitable relief to those defendants who fell within certain criteria and eligibilities. I believe that the criminal justice system is sophisticated enough to recognize and accommodate our changes in society. And if we are to continue to evaluate our current conditions relative to criminal justice and criminal justice reform by standards that were put in place years or decades ago, we will essentially be in a circular firing squad. A departure takes some conviction. There was a time when the death penalty was the rule or the law. That's no longer the case in Illinois. Those kinds of changes have to occur. And it's just too easy to rest on things as they used to be. In order to make a change and a difference, we have to step forward. Sometimes maybe out of our comfort zone. And with that, I'd like to call Ms. Lloyd.
Thank you, Judge. The main focus and goal, as the judge has said, is that we're going to look today to adopt a set of principles. Because so many of you provided information in response to the earlier draft, I think that's going to be an easier conversation than we might have otherwise had. And in your packet, there was a document that compared the original version to the comments and listed the questions that had come up. Before I get into the details of the agenda, I want to say to the people in this room that now would be a good time to get coffee since it arrived late. If you'd like a cup of coffee, it's available to you now. If the time permits today, we might get into a conversation about eligibility, and if we do that, Kathy is going to provide a factual and evidentiary background for that conversation and then lead us through that. Because eligibility and process and principles are such complicated and interrelated factors, I think it's going to be challenging to stick to the principles. And so Lisa and I are prepared to maintain a parking lot for issues that the judge or Kathy or anyone here thinks we ought to just park while we proceed through this conversation. Having said that, let me turn to Kathy to kick off the discussion of principles.
All right. We are going to share this, Chairman Salone and I. First of all, I want to ask everybody, for the people who are on Zoom who can't really necessarily see all of us, please identify yourself when you're speaking, when you're here in the room. Same for you on Zoom. If your camera's not on, we would appreciate it if you turn your camera on when you're speaking, but just so we're sure to have a clear record, I'll say. I'm going to let Chairman Salone give us a little rundown of how we're going to do this, but procedurally, we're going to put onto the screen each principle, and we will make edits as we discuss them, so in hopes of getting to language that we can vote on to be a principle that we adopt. Our parking lot is digitally documented, so you're going to see a little yellow square in the corner like a Post-it note. Abigail Drum, who is she's a SPACette, I'll say, and she's remotely joining us, and she will be keeping track of all of that. Joby, I saw your hand. Do you have something?
I did. I just a quick procedural question. You mentioned voting on the principles. At some point, could you remind us if we already know, or tell us for the first time if we don't, sort of what type of consensus are we trying to reach, or are we trying to reach consensus?
Well, you're getting ahead of me, Joby.
Voting. Okay, sorry. I just, when you had to use the word vote, it led me to wonder, and so I thought maybe other people are wondering as well, and I would ask the question.
Well, thank you. As you will recall, in our first meeting, we did vote on processes and procedures, and in that vote, we specifically adopted 2 procedures that are relevant. And that is that, first of all, people who join us virtually, that you count towards quorum and you can actually vote on things. And second of all, our governing principle is a majority vote. So half plus 1, and that will lead us to an adopted principle. When we get further into recommendations, we obviously will be, there might be a variety of opinions that we'll document, but the vote will be by majority vote. So with that, Abigail, I'm going to ask you when Judge Salone's finished with his introduction to put up, well, there it is. At the top, you see in the lovely SPAC purple, the revised principle that we are considering. On the bottom is a language that we will tinker with until we get to agreed upon language. And in the corner, the little green note is our parking lot. So, Mr. Chairman, I will hand it over to you.
Thank you. As to principles 2, 3, and 8, there was no comment or a proposed revision. And if that is still the case, I suggest that we adopt those by consensus.
And I will refresh your memories. Principle 2 is to authorize a fair, consistent, and proportionate mechanism for judicial review and specify the criteria for eligibility and identify the people or entities that can file petitions or motions for resentencing. Principle 8 is the prosecuting authority shall be properly served with the motion for resentencing and be given a reasonable time in which to respond. Woe be to anyone who would object to that. And number 9, an adequate record of the proceedings shall be maintained and the judicial decision maker shall be required to state in the order resolving the petition. I'm sorry, I was reading the original principle, let me go back. An adequate record of the proceedings shall be maintained and the judicial decision maker shall be required to state the reasons for its decision in the orders granting or denying relief. So the question is, can we have a motion to accept those 3 as described?
Question.
Yes.
Are you saying that there was no comment on number 3 as well?
You skipped 3.
There's comments on 3.
There are comments on 3.
So we're looking at 2, 8, and 9, is
2,
that
8,
correct?
Okay, I stand corrected. Are we ready for the vote?
We need a motion to accept those 2, 8, and 9 as revised.
So moved.
Who was that?
Joby said so moved.
Is there a second?
Mr. Daniels, second.
Thank you, Ms. Daniels. Ready for the vote? All those in favor?
We have to do
Roll call.
roll
I
call
forgot.
because we're so,
Sure.
all right, here we go. Chairman Salone.
Aye.
Bob Berlin.
Aye.
Cheryl Ingram.
Aye.
Kelly Cassidy. Representative Cassidy.
Sorry, I was struggling with my unmute. Aye.
Jen Passwater for Ryan Spain.
This is Spain, aye.
Oh, Representative, welcome. Joby Cates.
Aye.
Robert Peters.
Aye.
Sharon Mitchell.
Aye.
Ari Jones.
Aye.
Latoya Hughes.
Aye.
Yakov Delaney. Shobha Mahdev.
Aye.
Scott Main.
Aye.
Lisa Daniels.
Aye.
All right, just so I'm sure, has anyone joined for Senator Bailey? Okay.
Chief Davis says yes as well.
Oh, Chief Mitchell, I'm sorry, I missed you. I apologize. Okay. Ready to get into?
The vote is complete.
The vote is complete and we have
Aye.
unanimous adoption.
The motion passes. Principles 2, 8, 9 will be received by unanimous vote. And we go to principle one.
Yes, we can.
Principle one reads as follows: the revised principle. Provide for judicial determination of whether the purposes of sentencing embodied in the Illinois Constitution and the interest of justice would be better served by a modified sentence than the individual's completion of the original sentence based on the current circumstances of the individual and the victim of the crime of conviction, as well as changes in law, policy, and scientific knowledge. We did receive a comment, and it reads as follows. Most criminal cases are resolved. Well, let me ask, is there comment from the floor? From our video audience? I will make note of the one that we received. Most criminal cases are resolved with some type of plea. Blind plea, plea with the cap, plea with the floor and cap. Unless it's a true blind plea, the people are usually agreeing to drop certain counts. These agreements are entered into with consultation and consent of the victim. Principle one states that the inquiry on resentencing shall be on whether the interest of justice, quote, based on current circumstances of the individual and the victim of the crime of the conviction, would be better served by a modified sentence, close quote. Not only does this violate contract principles, but the current circumstances of the victim can only be considered as far as reducing a defendant's sentence. Principle 6 in the Constitution prevent a judge from increasing a defendant's sentence based on current circumstances. Would anyone care to elaborate? No discussion.
Do we have any contrary positions?
Not.
I think it would be really, this is Joby speaking, it would be really helpful to hear a little more from the folks or person who submitted this about their understanding of a contract in this context. That's something about this argument that I would love to learn and understand better as somebody who doesn't sort of inherently understand that as a like a given, an assumption of weight.
Well, I can say based on a little bit of legal research completed by me, the Illinois Supreme Court has recognized that a fully negotiated plea is a contract, and the parties to that plea, the state and the defendant, are entitled to the full benefit of their bargain. And there are processes in place in other contexts to set aside a plea that allow for reconsideration. So I think when you know, that's the baseline applicable law that I was able to find. And I will admit that I think it warrants some additional legal research. And that raises the question, you know, and those of you who are attorneys who have done this work are well versed in the, you know, the formalities of a plea where a defendant waives his or her right to appeal or waives something that's, you know, it's a specific aspect of the plea. So I think, you know, that's the governing case law with some qualifications. But in terms of how that would apply in this scenario and whether or not a victim would be considered a party to the contract, I've not found any case law on those two particular questions, but we will continue to look for it, and I would encourage anyone else who is familiar to chime in here.
Is there anyone who would care to speak in favor of the revised principle.
I see a hand, but I do not see it identified.
That is, yeah. And I raised my hand before the chairman prompted.
I didn't see it, sorry.
No. It was more to speak, and I'm trying to see how to lower my hand, so I apologize for learning WebEx on the fly. I was reacting more to what Kathy was saying in terms of the position of the Illinois Supreme Court regarding negotiated guilty pleas, and there are people in this meeting that are far smarter than I that could speak more to some of the ways in which courts have treated guilty pleas, and there are different forms of guilty pleas, both fully negotiated, partially negotiated, blind. There's a world of ways. There are instances in which it comes from the urging of the court, and sometimes obviously from the work of the parties. But my comment was that those statements from the Illinois Supreme Court and times in which courts rely upon contract principles are instances in which they are borrowing from sort of the civil side of the ledger. It is not simply true that contract law principles govern guilty pleas. There are contract law principles that are embodied within the guilty plea, but it is not an apple-to-apple comparison. It is not ever considered or thought of as sort of the notion of a classic contract in which two parties come together sort of on equal terms in which to come to a resolution or come to the classic sort of benefit of the bargain in which, and I won't get into more of that, but the notion of consideration, all of these wonderful concepts that we learned in our first year of law school, and then had to remember when we took the bar exam, and then we moved into practice and never thought of it really in those same ways again. But this long statement was really just to say the most recent time the Illinois Supreme Court was looking at guilty pleas that I'm aware of was from a case in the last year, which again talked about contract principles. But what I wanted to raise and share was that it also noted that in a fully negotiated plea, there is still discretion happening, and that discretion is happening on the part of the judge. The judge is ultimately the only party that really matters when it comes to a guilty plea. The state and the defense can negotiate until they're blue in the face with an agreement for what they want to do, but it's the judge who decides. It's the judge who is required to exercise discretion. So it is not a contract between two parties. There are at least three groups that have come to the table in order to come to this understanding and this agreement. And so I think what I see in the original principle and in the revised principle is a recognition of a change in circumstance that would allow for the parties to enter in that same conversation again in whatever way that the General Assembly has seen fit. So it is absolutely true, and I'm not disagreeing with Kathy, that contract principles are brought into play when evaluating guilty pleas, but they are not the only thing brought into play, and there is always discretion that has to be exercised. And so what this whole task force is sort of thinking about is how that discretion is sort of best served and where it is best served, and should it be, if when interests of justice sort of require, should that discretion be given back to the parties in order to evaluate what's fair? I'm talking.
Thank you. Thank you. Comment?
I have my hand up, Kathy.
And so does Representative Cassidy has her hand up.
Oh, go ahead, Cassidy. Go ahead, Representative Cassidy.
Actually, Shobha, before anyone goes, I would like to ask that at least one person in the room I know this is unpleasant and uncomfortable. I would have come in person had I not been ill for the past 8 days, and I'm just not risking things right now. But I think it's very important for at least one person to actively monitor hands being raised if we want
We
to
are,
keep things
Jody.
moving. I know it's not apparent.
So let me just ask this. We are monitoring. 3 people had their hands up. Give us a minute, okay? And we will call them in the order that we see them, not in the order that anyone is valued. So State's Attorney Berlin has left the meeting. So we're down 1 member. We had hands from Shoba and from Representative Cassidy. Representative, go ahead.
Sure. I think that Scott did a good job of sort of casting this sort of in the same way that I see it, but I want to speak in support of the added language to the principle. I think it addresses the need to be very thoughtful and mindful about what is and isn't going to get us into a footing of resentencing. And the fundamental reminder that we are not talking about issuing get out of jail free cards. We are talking about putting a case back in front of a judge to exercise their discretion. And I think that the prior comment seems to suggest seems to suggest otherwise or ignore that fact. So at the proper time, I move that we adopt the amended language.
Okay, Shoba.
Hi, I agree with all of that, and I do appreciate the added language and that there are defining circumstances that will lead to these determinations, and that judges have a critical role in all of this. The only piece I wanted to add to that contract discussion is one that might be obvious. I have looked at this nationally to some extent and on the federal side, and yes, there is a recognition that contract principles infuse or our understanding of this, but obviously it's not like you entering into a contract to buy a car, right? Like there are issues of control, of power, of structures that make pleas desirable to people, even under circumstances that you might not think are desirable to them. We see people who are innocent try to plead guilty to things. We see people who are, I've had young people who are going to be moved to Cook County Jail plead guilty in order to avoid some circumstances. So I think we should not ignore the power dynamic that exists, and there is a recognition of that nationally through articles that have been written on this scholarship and federal case law as well. So I just wanted to acknowledge that and also say that I think that changed circumstances are valuable. I do support the revised principle. Many of the things we've seen changed in terms of, I think, the opening remarks were correct that things have changed in terms of law and science and policy across the board, and offering these opportunities will be a reflection of that. It is certainly, and to put it the converse way, if we were to somehow try to circumvent guilty pleas, we would be ignoring a huge swath of folks who have pled guilty in our system and ignoring circumstances that may have changed that caused them to plead guilty and have now since been revised, changed, reformed, or should lead us to want to change circumstances. So I speak in support of that as well.
All right, I'm going to ask Nazgul. I don't want to put you on the spot, but is there anything from your perspective to add on this point?
No, I don't have anything to add at this point. The language that I see highlighted here looks very appropriate in that it captures the idea of changing circumstances, growing understanding of changing circumstances of the offense, as well as changing scientific knowledge and changing laws.
All right. And I would note as a practical matter, because we love to be practical, our task is considering these motions as a tool to reduce the prison population. And the majority of the people that we are looking at are in prison pursuant to plea agreements. So we would have a tough time getting to a meaningful reduction. Senator Peters, I saw your hand up.
I just want to second Kelly's motion. Thank you.
We'll call the question. It has been moved and seconded that revised principle number 1 be adopted. Ms. Director.
Okay, Chairman Salone.
Aye.
Bob Berlin is absent. Cheryl Ingram. Kelly Cassidy.
Aye.
Ryan Spain. Or Jen Passwater for, no, I see you, Representative, but you're on mute. We'll come back to you. Joby Cates.
Aye.
Robert Peters.
Aye.
Sharon Mitchell. Or Jim Jacobs. Oh, I see Sharon. Ari Jones. Aye. Latoya Hughes.
Aye.
Yakov Delaney.
Aye.
Shobha Mahadev.
Aye.
Scott Main.
Aye.
Lisa Daniels.
Aye.
Chief Mitchell. I'm sorry, Chief Davis.
Aye.
Okay.
I've been called worse, so I'm good.
It's bad enough I left you off the roll the first time. I'm going to go back to Representative Spain. If you are voting, you are on mute and we can't hear you. Or Jen Passwater. Okay, well, we do not have a vote on that one. So I'm going to write abstain for now and we can revisit if needed. Okay.
The ayes have it. Revised principle number 1 to be adopted. We will now go to principle number 3. There are no revisions. It reads as follows: specify the time frame in which the right to reapply after initial eligibility shall recur. For example, successive petitions can be brought every 3 to 5 years. Comments are as follows: must balance the interest of the individuals and the need to avoid flooding the courts, as has happened with post-conviction petitions. A longer time period between petitions would allow for further change on the petitioner's part to support subsequent motions. Number 3, 5 years should be the minimum time between petitions. The fourth comment is, should there be a limit on how many times a person can apply? Comment?
I do. Ari Jones, Cook County State's Attorney's Office. So in terms of the question of should there be a limit to how many times a person can apply, I think of that in terms of those who are eligible, or will be eligible for youthful offender parole. So those who are convicted of first-degree murder, they can apply a total of 3 times before they lose that right. If they're denied the first time, they wait 10 years, apply a second time. If they're denied a second time, wait 10 years, apply a third time. And so, in a way, to avoid the glutting of the courts for whoever made that comment, that might limit that. Because again, as someone pointed out with the with the PCs and the 21401s, that those processes continue ad nauseum and indefinitely. And so having a limit on how many times a person can come to court with this resentencing motion may avoid that. It's also, I believe, something that's done with the resentencing through the DC Second Look program. I believe the man who presented to us in the first or second session whenever he came said that they only have 3 opportunities to file those motions. And so that would kind of check along with that process they adopted in DC. In terms of the 3 to 5 years, I know that's just an example for successive petitions. I guess I wonder, in terms of filing one every 3 years, is that long enough for there to have been a significant change in circumstances that would compel a judge, especially if they're going back before the same judge to have to make a different decision what in 36 months will have changed so significantly that would have compelled a judge who just saw this petitioner to make a decision contrary to the one they made 36 months before. And so it appears to me that a longer time frame would give both the petitioner a greater opportunity to, I don't know, add more programming to their accomplishments list if that's what the judge is looking for, or just if they're trying to be strategic, wait out a judge's retirement and see who gets their case next. And so I think they're, whatever happens. And so I think that a longer time frame might actually just be strategically beneficial to them. But again, I think it would also avoid the flooding of the courts for the person that made that comment.
So are you talking about 5 years as a minimum time frame?
To me, 5 years is still too short, but yes,
Okay.
five would be the absolute floor.
Sure.
So are we talking about, are we anticipating that most of the petitions will come from people charged with murder?
If it's
Yes.
for folks serving longer sentences, it's usually those who would be in for murder, 3 strikers, which we'll get to mandatory minimums later apparently, and those who are convicted of sex crimes.
So I think if you're talking about, if those are the offenses that we're considering, the public at large will be happier, as she indicated, with a longer period of time before you can first apply. And definitely a limit on the number of years you can apply and when you can reapply. I should have said third, second, but you get the point.
Okay, Joby, you had your hand up? You're on mute.
I just want to note, this is Joby, that the principle itself says in both versions, for example, successive petitions can be brought every 3 to 5 years. I think for the parking lot, it may make sense to talk about a range of years, and I would have at that time a really strong argument that what can change in 3 years could be documented in every study of human behavior ever conducted. And I will be thrilled to have that awesome, robust discussion then. But for the purpose of this particular principle, I don't think the principle is written to say, and if it was shall recur, comma, and successive petitions can be brought every 3 to 5 years, then we could argue that now. But because the words, for example, are in there, I think, we could just go ahead and think about the principle and not the example in the principle.
So I acknowledged in my original statement the phrase, for example, but I also think that it is wise to get this information out there at the outset, because the fact that it is added in there, even as an example, welcomes that at least initial comment so that it's on everyone's radar. So again, that was acknowledged that this is just, a suggestion at the outset, but it is something that needs to be addressed up front. If the language weren't there, it wouldn't be a comment that I had made, but since it is there, I think it's very much open to discussion.
Okay. Because I would argue then that the U.S. Supreme Court in Miller, and was it Graham or Miller? Somebody will correct me. Used the term meaningful opportunity for release, trying to get around using examples or specifying terms of years, and that not having an example or range was problematic. So Ari, I see what you're saying, and I apologize. I didn't understand your complete comment. Thank you.
All right, we have Senator Peters and Representative Cassidy have their hands up. Kelly, I saw your hand first, so take it away.
Honestly, just, if we're going to go down this rabbit hole, numbers are arbitrary. Maybe what we should be talking about is demonstrable change of circumstances or something like that, and not putting some random number that may or may not have anything to do with the circumstances of the people that we're talking about here. You know, we can argue 1 year, 5 years, 10 years. We could do that till we're all dead. Numbers will always be arbitrary with regard to humans. So maybe we talk about circumstances instead.
All right, Senator Peters?
As how it usually goes, Kelly said everything that I would say anyway, so whatever Kelly said.
By the way, today is the first anniversary of Robert Peters Day.
Wow.
I apologize. Yeah, it's the day we signed all this stuff. So happy Robert Peters Day, everybody.
Cheryl?
Well, I think we need to use numbers in terms of parameters to give the system or the prisoner and whoever else and their attorney or whoever else that we determine should be able to file these petitions a baseline to start with in terms of demonstrative evidence of whether or not there's been any rehabilitation. I think that's a factor that we put in terms of the decisions that the judge has to make once it comes to court. But I think I read the principle in terms of notifying the population that's going to do this of when you're eligible to do this. These are the limits and how many times you can do it. Because quite frankly, they know what they've been doing the first 4 or 5 years. They know how many fights they've gotten into, whether or not they should apply. But if you choose to, be aware you only got 2 more times left. So maybe you want to wait until you get yourself together. So I think it's a baseline of this is the criteria. You can't even get here until this time frame. So that's how I read it.
So I think what I'm hearing here is we have 2 of the interests that we identified in our first meeting competing here. One is the interest of the individual, and one is the interest in managing the resources of the system effectively. So the principle as written is to specify a time frame in which the right to reapply, not the initial, we're not talking about the parameters for the initial petition, but after you have had, you've reached whatever eligibility criteria, the time frame in which you can reapply after you've had your first shot. And I'm hearing 2 different things. One is we need to center meaningful change in the individual. 2 is we need to have a reasonable boundary so that we don't have with resentencing petitions the situation that has been, that has happened with post-conviction petitions and other post-trial motions. So I think maybe the first question is, and maybe we vote on this, do we want to specify a time frame and put the parameters around the ability to reapply?
Chief Davis and Chief Davis has his
Okay, I'm sorry, we have 2 hands up. Chief Davis and Nazgul, I think. So Chief, why don't you go first?
Yes, just an additional consideration when it comes to determining if and how many years, when we're talking about time frame for reapplication. I also want us to keep in mind that we want to minimize the re-victimization. So I think I just want to make sure that we take that into consideration if we choose a time frame as well. Thank you.
All right. Do you have any feelings specifically about whether we should choose a time frame?
I don't have a challenge with the time frame. Like I said, I just want to make sure that we don't have an unlimited number and that it's so free, because that's what I hear from victims sometimes, is that I'm reliving this, having to go back to court over and over and over again. So just making sure that we take that into consideration when we're doing the totality of this.
All right. Nazgul?
Thank you. I just wanted to add in to the mix here of consideration a couple points. One of them is that the recommendation that I've seen from national parole experts in terms of thinking, which I think can be kind of transferred over to this conversation. So some of the experts that I'm thinking of in particular, they're Edward Ryan, Joan Petersilia, and Kevin Reitz. And they've examined a lot of parole issues and given recommendations for how parole consideration should happen. And they have things to say about when the first parole hearing should happen. And I can talk about that later when you're talking about when the initial hearing should happen. But with respect to how often subsequent hearings should happen, I think it's notable and worth considering here that their recommendation is that it should happen annually. And they say that in rare circumstances, they should happen, the wait time should be 2 years. So, it's a shorter period of time than you have in the range that you're considering here, but it's worth considering. And one of the reasons for that, I think, is with respect to resentencing consideration here, is that the period of the minimum time that's discussed here, 3 years, I've been hearing you discuss, how much can a person change over that amount of time? And I think there's a general tendency to sort of underestimate how much time is when it's about prison time versus if we think about what happens in our own lives over 3 years, for example. But one thing to consider, in addition to how much a person may individually change over 3 years, is how much might laws change over the course of 3 years. And if we have reforms, for example, to felony murder laws, to youth sentencing, to sentencing for young adults, what is the period of time that somebody should have to wait in order to benefit from those changes that the legislature is making so that resentencing laws can apply those reforms to their particular sentence? So I think that that's something else to consider in addition to the amount of change that we can expect from individuals, how rapidly right now we're in a phase of sentencing reforms and scaling back extreme sentencing. And often that's not done retroactively. And these resentencing mechanisms are a way to apply those reforms to the prison population that's already serving time. And I think I'll conclude with that.
Scott,
I see a hand up on the video and then Ari.
Scott Main as well.
Who?
Scott Main.
Oh, Scott, I'm sorry. I'm getting this weird, I want to make clear, I'm getting this weird symbol that just shows a hand without putting it in your block. So Scott will go with you and then with Ari.
Well, I took my hand down, so that may have added to the confusion in part because Representative Cassidy put into the chat basically what I was going to say. And I was a little bit nervous about saying it because I, got nervous about Robert's rules in terms of whether or not I'd be putting it onto the floor, but basically like looking to eliminate the number from this principle because I think principles are just that. And numbers is the sausage. That's, that would have to be hashed out in the actual, the eventual piece of legislation authorizing resentencing. What we're talking about here is a principle for resentencing that would involve that all of our principles are informed by that there is a right to reapply. That it's not just going to be the one review, that there will be that we believe there should be multiple opportunities.
We're not on the chat.
Can you please do not use the chat because we can't see it. So please raise your hand and say whatever you want to say. Ari?
Yes, two things. I would agree with Scott in terms of just removing the example language in for the suggested principle. So I think that would be a great idea. But also to Nascal's point about the parole board, the suggested rehearing for parolees or potential parolees, I think that's a great time frame for parole boards that are convened specifically to consider whether a person should be granted parole. The judiciary is not a parole board though, and they are not convened specifically to hear resentencing motions. They have a host of other duties, cases, and complete dockets worth of things. And so in considering that time frame or whatever the time frame will be when we are getting to that point of determining whether there should be a time frame, whether there should be a limit on the number of petitions that a person can file, I think we really have to couch that consideration in the reality of who these petitions are going before, and not just, oh, this would afford them a meaningful opportunity for release. Certainly that is what we want. We want people to have a meaningful opportunity for release, since basically parole was gutted in 78. But if the way that we're going about this now is going to be through the judiciary, it does have to be practical to the body that they would be going before.
Okay, so Abigail, why don't you go ahead and edit our principal to give yes.
And then
Just
Kelly and
period.
Nazgul?
All right.
Can we,
Kelly, I think we have other hands. Kelly, is your hand up?
Yes, it is.
Okay.
And again, within whatever the proper formatting is, I think that, when I first read this, I felt like time frame was the way to go. Listening to folks, I think that if we talk about it just as a time frame, does that preclude us from not using numbers and instead using specific circumstances? So I would prefer us to be even more broad, either to say specify the time frame or circumstances, or just say circumstances in which the right to reapply after initial eligibility shall recur. And if folks want to add to that a statement of, or a limit on the number of times or something, that's fine too. But I think that, in particular, I don't remember which speaker brought up, future sentencing reforms that might impact somebody. That is a circumstance that, regardless of how long ago their petition was denied, that circumstance is significant to their case. If their charge has a much lower sentence now, so I feel like we need to give ourselves a little bit more flexibility.
Okay, so revamp the language to say specify the time frame or circumstances in which the right to reapply after initial eligibility shall recur. Is that what you'd like to see, Kelly?
Yes, and I am open to, a second sentence about a limit on the number if people feel that strongly about it. But
okay,
again, without establishing a number and whether there should be a limit. I'm open to that if folks want that.
All right, so let's put in the parking lot the question of specific numbers and limits on the overall number of petitions that could be filed by one individual. Cheryl, did you have your hand up?
Nazgul.
Oh, well, we'll go to Cheryl first. We'll do now. We will do members first, Nazgul, and then we'll get back to you.
So if we're talking about resentencing, if we're talking about a new method to be resentenced if you've committed a crime that results in an extremely long prison sentence, if laws change, you automatically have the right to go back to court and file whatever motion you want anyway, even if we didn't exist in this task force. So I don't think that we have to set our parameters based on what already exists. It seems like we're saying our parameters are based on this new thing that the legislature hopefully will figure out how to work. But I would leave it to the legislature to figure that out, because I've seen what comes to us. And so I would suggest that circumstances not be a part of it, because there are means to deal with circumstances if they change. And as Ms. Jones said, same thing with parole board, they do something different. This is geared toward people who have extremely long sentences, and after we assume they've done enough time for the crime that they were convicted of, and the families have had an opportunity, which we're going to get down to when we start talking about the family and the victim and the defendant getting together, that this is a good time, that maybe this person doesn't need to spend all that time in prison. So that circumstance is very different than the change of laws. I mean, we're trying to create something different. And if you just say circumstances, it's too broad. And I think you do need a time frame, because if you don't put a time frame in, you're gonna run into the same thing you have with post-conviction hearings. Because someone who's there for 20, 30 years don't have anything else to do.
Until DOC gives
I'm
them
from
program.
Working on it,
working on it. Okay, so what do we want to do?
We have to move this along.
Yeah.
We have to move it along.
So based on the comments.
Yeah, Nazgul, why don't you?
Thank you so
chime in
much.
here?
Thank you. I'll just be very brief. I wish that description were accurate, and that when laws change, people already sentenced would be able to automatically benefit from resentencing. But my understanding is that is not the case in Illinois. So for example, in 2021, the legislature scaled back the felony murder law, but it did not apply that reform to people that are already sentenced. So unless it's stipulated that the law is retroactive, there's no mechanism by which people can be resentenced. And this is an important role that you're playing here to create that mechanism. The other point I wanted to make is, and I defer to those of you who work in the courts to think about the significance of this, is that in terms of workload for the courts, I know that this is a major concern about resentencing, but one of the arguments I've seen by Cecilia Klingel, who's a University of Wisconsin law professor, is that we need to keep in mind the fact that when people are not able to access petitions for resentencing, they are still petitioning the courts in other ways and submitting other motions. And so this process would help to channel those other ways that they're trying to reach the courts to request mercy. And so I would ask you to consider that as well.
Can I make one final comment? Just to I'm sorry, one very quick final comment. If the issue is that the sentencing laws are changing, but they're not being retroactively applied, then I would think that the issue lies with the legislature and the need to make those laws retroactive, not to continue to expand an incarcerated person's opportunities to possibly glut the courts, which was the phrase that was used.
Right, and that is in one of our other principles. And I will just say this, practically, automatic anything is not a good idea. So I think that that's not on the table, that there's a change in the law and there's an automatic reconsideration. I think there's a process, just because the system can't handle it. And we're also balancing, when we talk about the resources of the system, the right to people who are approaching trial to have a speedy trial and to have a resolution. So it's not just, that's part of this mix in weighing the needs of the system. So I think what I'm hearing is that we agree that we are going to have as a principle that we should specify some boundaries around this, whether it be in terms of a time frame, a number of petitions you can file, or the circumstances in which the right to reapply after initial eligibility should reoccur.
We have Jody and Kelly.
Well, we need to move on. So I'm sorry, guys, I know there are some hands raised, but we have 10 other principles. So is it okay to move on?
No.
Okay. So looking at the revised language, do we have a motion to either accept or reject that?
Make a motion to reject.
So moved.
Second.
Well, we have two motions. We have one motion to reject it. Kelly, and that's based on the inclusion of circumstances.
Circumstances and no time.
Okay.
But that's the only motion.
Well, no, then Kelly moved.
She second.
No.
No, I
she
didn't
moved.
second the motion to reject. I moved,
All right, so
I moved to accept it and Robert seconded it.
All right, so the first motion from Cheryl is to remove or circumstances. So we would only have specified the time frame as a principle that we will get to specifying the time frame.
In a separate principle, is that what you're saying?
No, that's going to be in the process meeting.
So right now, this is just a principle. It's not what we're actually going to have like going forward. This isn't final.
This is a commitment to do it.
Yeah.
We're saying that we need parameters around reapplication.
You know, I'm gonna stick with my rejection.
Is there a second? Well, there's a motion on the floor. So the maker of the motion, would you repeat? I'm sorry. Repeat your motion.
Kelly, can you repeat your motion?
I thought the motion on the floor was to reject.
Okay, we'll take that up.
No, I'm trying to figure out what's going on.
Yeah. You're asking that do we accept this principle as amended?
And you say no, but my question is if we took out or circumstances, so that what we are agreeing to is a principle that requires us to set parameters around reapplication.
Well, then take out time frame or circumstances and say parameters.
Okay, so erase the whole thing, Abigail.
She got it.
Okay, okay, Abigail, this is for you. Specify the parameters under which the right to reapply shall reoccur.
And I'll withdraw.
Okay, so now, do we have a motion to specify the parameters under which the right to reapply after initial eligibility shall recur?
So moved.
Okay. We have two movers. Second. Okay, Kelly moves, Cheryl seconds. Here we go. So this is number 3. Chairman Salone.
Aye.
Berlin is not with us. Cheryl Ingram.
Aye.
Kelly Cassidy.
Aye.
Jen Passwater for Ryan Spain. Jen, can you take yourself off?
Yeah, I'm going to abstain for Representative Spain.
Okay. Joby Cates.
Aye.
Robert Peters.
Yes.
Sharon or Jim?
Issue on this last, so I would say yes.
Okay, Jim for Sharon. Ari Jones.
Yes.
Latoya.
Yes.
Yakov.
Yes.
Shoba.
Aye. Yes.
Scott.
Aye.
Lisa.
Aye.
Lisa. Okay. And Mitchell Davis. Do I see?
Aye.
There you are. All right. We have all ayes with one abstention.
Okay, the
So we're
revised
on.
principle reads as follows. Specified parameters under which the right to reapply after initial eligibility shall reoccur.
That's the one we just voted on.
Yes.
And that's.
That passed.
Yeah.
Number 4 reads as follows. Specify how individuals who are incarcerated shall be notified of the right to file petitions, provided adequate assistance in preparation of petitions, such as whether such assistance may be provided by either counsel or non-lawyers, and whether such assistance shall be provided without cost to petitioners. Comments are, number 1, several members raised the issue of right to counsel and how counsel would be provided. 2 interests were identified: the need for drafting help and the constitutional right to counsel at critical stages in the process. In addition, there is a right to appeal counsel to appeal, counsel is needed to perfect the appeal. Number 2, IDOC staff be precluded by collective bargaining rules from aiding with drafting the petitions. Legislation should address resources for outside organizations to provide legal assistance. Comment?
Well, I know speaking for Sharon, unfunded mandates are not good, so if there was going to
Can
be.
you speak up a little bit, Jim?
I said, I know that Sharon would point out that if there going to be a right to counsel in these circumstances, that funding should be made available for that counsel.
Right.
More of a comment, just if assistance will be provided by non-lawyers, and this might be something for Shoba and any other law professor, would that come from just law school clinics or something like that? If it's non-lawyers, that would possibly address also the need for funding if it was counsel. And if so, would that be something that needed to be like in this language? So I'm not trying to follow Western, but just curious about how that would work in reality. And I think she had her hand up too, so.
Okay, we have 2 hands up, but I don't see who they are. Do you know?
I saw
Susan?
Shoba's.
Okay, Shoba and Joe. Shoba, you go first.
This conversation I think did come up. Thank you, Ari. I hear what you're asking. It came up in the youthful offender parole bill too, and I think the issue is that you do need some level of legal assistance. I'd be concerned about saying non-lawyers in a principle. It seems fraught for all kinds of abuse. And to answer Ari's question more directly, if you're talking about law students have to act under the supervision of lawyers too. If anything's going to be in court, if something's not in court, there may be some ways around that, and drafting. But I would have, I would have serious concerns about something that flagged non-lawyers as providing assistance. We can decide how far we want to go in the principle, but I'd be concerned about that. And I think thinking that law school legal clinics could do that would not solve that problem, for instance, just because you require a supervising lawyer in those circumstances too.
Do we want to suggest a change to the language?
So
if you call on me, I have a suggestion, and it's
go ahead, Joby.
the same one Shoba's about to make. Do you want to?
No, go ahead.
This is the exact same conversation we just had. I would argue what we do is we end the sentence at petitions with a period, because this is a principle, not a recipe or a strategy or a policy proposal. And I think if we get into this discussion now, it'll be the same conversation we just had, but on a different topic.
Okay. So we end the sentence at petitions. Abigail, give us that change.
At which petition?
File petitions, period.
In separation of the petitions, period.
Do we want just to file petitions, period? Or do you want adequate assistance included?
No, first, petition,
period.
Joby, which one were you talking about?
Honestly, at this moment, I'd take either one, because fundamentally, as a principle, one's good. If you stop at the first petition, it's a little better if you stop at the second petition. Right. Either way, we are going to be wrestling with this issue at a time when we've already agreed that the basic principle is people ought to be notified of this goddamn thing.
All right, put the period there, Abigail, and get rid of the rest of it. Knowing that we are going to, in our process meeting, of course, address the right to some kind of health. I would just note that one of the things the Illinois Supreme Court is paying a lot of attention to these days is how to help pro se litigants. And I think that's the question. How to help pro se litigants in some way. We don't necessarily need to get into that, but this is a nice, clean, very simple principle.
Let's vote on it.
We have a motion.
So moved. Lisa
Second.
Daniels.
Second. Really?
I'll second.
Second.
Thank you.
Oh,
Okay.
you know, I was listening to you.
Okay.
All right, here we go. Chairman Salone,
Aye.
Cheryl Ingram,
Aye.
Kelly Cassidy,
Aye.
Jen Passwater for Ryan Spain. Jen? All right, we're gonna pass, we're gonna skip over you and come back. Joby Cates,
Aye.
Robert Peters,
Aye.
okay, Sharon, I'm sorry, Jim,
Yes.
Ari,
Yes.
Latoya,
Aye.
Yakov,
For clarity purposes, we're voting on the second one, right?
yes.
Revised.
Shoba,
Aye.
Scott,
Aye.
Lisa,
Aye.
Davis.
Aye.
All right. Jen Passwater, do you want to enter a vote or an abstention? She may have left the meeting for a moment.
She's on mute.
Jen, you're on mute. She may have stepped away. Okay. With the exception of a vote for Representative Spain, it's unanimous.
It reads as follows, Mr. Glenn. Specify how individuals who are incarcerated shall be notified of the right to file petition, period. That carries. Number 5. The revised principle reads as follows. Provide for screening and dismissal of applications that lack merit on their face. There are 2 comments. Eligibility criteria for the petitioner to file such as length of time served, sentence imposed. The second, criteria to state a cause of action. Comment.
Scott?
I'll make a very brief comment, and this is just, I agree with the progress that we are making and that we are moving forward. And I appreciate that we're all coming together on this. Having eliminated the language that we just eliminated in the previous principle, I want to make sure that we're real strong on our parking lot and a commitment to return to that parking lot, because now we have taken out the language of wanting to make sure that adequate assistance was provided in the creation of the petition. And now we are moving into what is necessary, I believe, that there should be a screening mechanism to dismiss certain petitions that lack merit on their face. I don't disagree with that as a principle. But having just taken away potentially the notion of adequate assistance in drafting that petition, I don't want to gut. I just want to make sure that we remain committed to our parking lot and resolving that as we move forward.
I will say that our plan for the parking lot, and I think a lot of this stuff is going to come up in our process meeting, but our plan is at the end of this meeting, we will put together a document that for all of you guys as a reference, the ideas that were put in the parking lot, and then we'll make some suggestions about how to handle them. So, yes, we are committed to returning to the ideas in the parking lot. And I reserve the right to, make some notes to you about some additional things that maybe didn't end up being discussed, but are going to have to come up as we go forward. So, we will leave no parking lot idea behind.
We ready to proceed to a vote? All those in favor of the revised principle as stated, please signify. Ms. Director.
Did we have a motion?
We did,
Okay.
didn't we? Hold it.
Did we have a motion on, I don't think we had a motion on
No.
this one.
Okay. I'm sorry. Is there a motion?
Latoya Hughes. I move.
So moved, Latoya moves. Do we have a second?
Second, Davis.
Okay, and before we do the roll call, I'll just ask Abigail to put the eligibility criteria and the criteria to state a cause of action in the parking lot. So those will be things that we come back to. All right, so Davis was the second, Latoya Hughes was the motion. Chairman Salone.
Okay, it's been moved and seconded that the revised principle, which reads as follows: provide for screening and dismissal of applications like merit on their face is the matter on the floor. Aye.
All right. Cheryl Ingram?
No.
No?
As a state.
Do you want to suggest a different?
Oh, I can do that.
Yeah.
Okay.
Actually, hold on. We'll go through the whole roll and then we'll
Okay.
come back and see if we can modify it. Okay. Kelly Cassidy?
Aye.
Joby Cates?
Aye.
Robert Peters?
Aye.
Jim Jacobs?
Yes.
Ari Jones?
Yes.
Latoya Hughes?
Yes.
Yakov? Shova?
Sorry, my mute. Aye.
Scott?
Aye.
Lisa?
Aye.
Davis?
Aye.
All right. We have one no.
The
And the
the
rest
aye.
ayes.
The ayes have it. Revised principle number 5 will be adopted. No,
No.
Did you have any?
no discussion.
Well, it's only me, so it doesn't much matter.
All right, we'll get back to that. I was interested in hearing your thoughts, but we do need to
But,
move
but I would
on.
suggest you put in, let me just say, I don't know what you mean by provide screening and dismissal for, applications of like merit. I think once you set the criteria, then the court automatically does that anyway, so I'm kind of lost there.
Maybe
Why-
not necessary.
Yeah, why it's there,
Okay.
once we know what the criteria is.
Okay, number 6, the revised principle reads as follows: provide authority to the judicial decision maker to modify any aspect of the original sentence. The time to be served pursuant to the modified sentence cannot exceed the unserved remainder of the original sentence. Provide that the sentence modification authority under this provision shall not be limited by any mandatory minimum terms of imprisonment or mandatory sentence enhancements that foreclose consideration at the original sentencing of petitioner's circumstances and characteristics. There was one comment that reads as follows: if the resentencing judge is not limited by mandatory minimum terms of imprisonment, then there will be no such thing as a mandatory minimum. This is a major concern for the state's attorney. Comment? Yes.
I'm going to suggest that we provide that we remove the entire final sentence regarding mandatory minimums, simply because in recognition of the statements that others have made about guiding principles versus process, this sentence is going to get us more into the process portion of it instead of the principle portion.
So should we put that in the parking lot?
I really think we should, because if not, this is going to devolve into like an hour-long conversation.
Only an hour?
I'm being
I think
judicious in
today.
saying an hour, but we can do this if you'd like to today, but out of respect for both everyone's time and the fact that previous conversations in some of the other principles have devolved into like deep conversations, and this one in particular has both legal ramifications, and I know State's Attorney Berlin would possibly have things to say about this. I really do think this should be placed in the parking lot until a later date.
Okay, so Abigail, why don't you put the second sentence
The third sentence.
I'm sorry, is it the third sentence?
Yeah.
Yes,
It
third
begins at
sentence.
Provide that the sentence modification, just parking lot.
Put that in the parking lot.
Any other comment? There being none, are we ready to vote on
Oops, wait, Shoba, your
Oh, I'm
hand's
sorry.
up.
Sorry. I guess I have a process question, a little bit, maybe a slight substantive comment. And this relates to Scott's earlier point when we were talking about the council and the nitty gritty of that, and how the conversation we're having about process generally, which is some of these principles should probably be more just general, but there are things in this parking lot which is turning into something quite robust. And I guess one question I kind of have for everyone to ponder over is, if after later conversation in that parking lot about all of this stuff, we then later decide something is worthy of being elevated back to these principles, is that something we would be able to entertain? I don't know if there's an answer to that, but I just wanted to flag that, because if we're going to have these conversations sort of later about the nitty gritty, we may decide we have greater consensus on some aspect or another. And that's related to both, I think, that council point and assistance point that we were talking about earlier, and maybe this mandatory minimum one.
I think that the planning team's kind of view of this is that what comes next is we get down to crafting recommendations. And that recommendations are at a higher level than principles. The principles will be kind of our structure that we can go back to if we hit a roadblock. We can say, well, like we did, with our processes and procedures. These are kind of the guidelines that we are going to depend upon. And, remembering that these were formulated by the American Law Institute, that we're not just pulling these out of thin air. So Ari's point about, it is a very significant legal question and equity question and fairness question, knowing what we know about mandatory minimums and how they have impacted the use of incarceration. So I think we wouldn't need to elevate something to a principle unless we're taking it out of a recommendation. But, we can always talk about it.
That makes sense. Thank you, Kathy, for that. And I guess on that point, I'm okay with it being in the parking lot. I do sort of maybe agree with the premise that's been put forth out there that that we should. I would advocate for us thinking seriously now or down the road as we craft recommendations about mandatory minimums, that they have been a tether to these extremely high sentences, and have caused situations where people cannot have come under them, and maybe it's because they were overcharged, maybe it's the circumstances of the statute or whatever. And so I would advocate for us thinking about how this resentencing task force and these recommendations intersect with being able to undo some of the damage there.
All right. Any other? Pardon? Just speak up, Susan. I can't see the
Robert
things.
Peters.
Robert Peters, your hand is up.
It was, now it's disappeared.
No, I'll still say this. I think that if we're going to take out a large chunk of a principle, that is something that needs to be presented as a motion, even if we have it in the parking lot, because honestly, I just think that it's just a huge piece of the principle that we're like, well, we'll talk about it later. And I don't know, but I feel like that's a way to then either not talk about it in the future, if we do talk about it in a different circumstance or a different situation. And I would say that if we're going to remove something because we don't want to have an hour-long conversation, that's cool, but we need to actually maybe vote on it to move it into the parking lot. I don't think it could just go into the parking lot.
Do you want to make the motion to vote on putting that in the parking lot?
I think the person who suggested put it in the parking lot should be the one who also suggests whether it goes into a motion to put it in the parking lot, because I want to keep it as is, so.
Isn't that then, should we have been doing that for all of the other things that are in the parking lot, making motions to put them there?
Well, if, so you
could've-
would vote
wait,
on
wait,
the change.
Let me back up. We could have, but we didn't, and here we are now. So I mean, like, whatever happened before, that's fine. In this situation, I'm making a suggestion that we should, maybe I should do this. I suggest that moving forward from this point on, that anything that is put in the parking lot needs to be voted on as a body. And I am making that suggestion. I would like to make a motion to vote on moving something into the parking lot.
Well, given our agenda, this is our last one for the day. So,
I want to point out a process question. I'd like to take this moment to let everyone know a little bit about what the planning team anticipates, because I think it's relevant here. We anticipated that this discussion of principles, which is really about values and a framework of values for going forward, would actually bring up issues of eligibility and definitely issues of process and procedure. And the idea behind the parking lot was to figure out what pieces needed to be taken out of a principle statement, because they're really about, if you will, implementation issues down the road. The planning team would then take the parking lot items and put them into the next two meetings, which, as you might recall, are now scheduled to be 4-hour meetings, which would allow for the kind of time that we need to have these kinds of conversations. And so I just wanted people to understand how we anticipate using the parking lot and what's going to happen in the next couple of meetings.
that was all in your cover memo. Yeah, which I know you all read. So does that help, Robert? Whoops, Robert's camera is off, so he may not be there.
No, I'm here. That's fine. I'm just trying to use the rules of Robert's rules to say it's just a way that you do when you use Robert's rules. It's fine. It's cool. Put it in the parking lot. I get everybody does not want to actually go through this whole rigmarole. So thank you.
Okay, so can we vote on the amended revised principle number 6?
All right, John.
To read as follows. Provide authority to the judicial decision maker to modify any aspect of the original sentence. The time to be served pursuant to the modified sentence cannot exceed the unserved remainder of the original sentence.
All right, John, so moved.
You move?
Yes.
Okay. Second.
It's been moved and second.
I'm sorry,
There's a question on readiness?
Because Senator Peters had actually made a motion, do we need to hear, there was no entertainment for a second on Senator Roberts rules motion. And I actually don't know the answer, but do we need to address that first before we proceed on what Ari just moved?
I don't think he actually made the motion, but Robert Peters.
I made the motion.
He was asking that Ari make the motion.
No, I actually did make a motion on making a motion because Robert's rules.
I'm sorry.
You're fine. I will actually remove. I take back my motion, and thank you.
Well, we can vote on it going forward. We would vote on. Okay, here's the deal. Going forward, we would vote on things being put in the parking lot. I will just note that if we have people on video, every single time we would make a change that goes in the parking lot, we would have to do a roll call vote. If you're all in the room, we can do it by voice, and I'm happy to do it. So Robert, Senator Peters, do you want to still withdraw your motion, or do you want to go forward with it?
I'm going to withdraw my motion, but I will say, to finish with this, that I still think that if we are going to remove something and move it in the parking lot, and talk about having a debate at a later day, that there almost needs to be a debate about removing something, but that's fine. I withdraw my motion, and we can talk about it at a later time.
We can put it in the parking lot.
I think we should.
Or we
let's put it in-
can take it up, we can take it up at the next meeting.
Yeah.
I don't want to ignore your concern.
Yeah, thank you.
Okay,
Back to the vote.
we have had a motion and a second on the revised principles. So Chair Salone,
Aye.
Cheryl Ingram.
Aye.
Kelly Cassidy,
Aye.
Joby Cates,
Aye.
Robert Peters,
Yes.
Jim Jacobs.
Yes.
Ari Jones.
Yes.
Latoya Hughes.
Yes.
Yakov Delaney.
Aye.
Shoba.
Yes.
Scott.
With the need to make a short statement that any aspect to me means that we are keeping a part of our conversation. Any aspect would mean departure from mandatory minimums is on the table. Aye.
Yes. Okay. Lisa Daniels, I think she had to leave.
I'm here.
Lisa, are you still there? Okay, Lisa.
Still here. Aye.
And Mitchell Davis.
Aye.
All right.
Ayes have it. Motion passed. Going on.
We're going to move on in our agenda because we're down to our last 20 minutes, 15 minutes. I think I already covered. We're going to move on in our agenda because our time is running to the end. I just want to reiterate what Susan said about our next meeting. It's going to be a longer meeting. We'll complete these principles and then get on with our discussions. And I do appreciate the very robust discussion here today. So now we are up to the time for public comment. So again, this is just kind of a limitation of WebEx. I don't know who you are if you have called in, which means you are a member of the public. So please raise your hand and then we will call on you by virtue of your, I guess, first 3 or 4 numbers of your phone number if you would like to make a public comment. And I would just say, reiterate for the record that if you make a public comment, please limit your comments to 3 minutes and please limit them to the subject matter of this meeting, which was obviously the principles that are going to govern our work going forward. So, is there any public comment? I'm looking hard for hands, but I do not see any. All right. Susan, I think we may need to go over, do we need to go over the procedures for the next meetings or just close it out? Okay, Lisa?
Yeah, I just want to know, in closing, are there things that you want to share that really struck you, things that you want to make sure we focus on besides what's in the parking lot at the next meeting? We're not going to do a round. I feel like we've had a robust conversation already. No closing thoughts this week or this meeting? Want a motion to adjourn?
Joby, your
No.
hand is raised.
Sorry, Joby. Really hard to see here.
No worries. I think I just want to say thank you to everyone for participating in this meeting. I want to recognize that it was a little frustrating and difficult for both the people who took the time and the effort on a rainy day to be in the room together in person. It was also difficult for those of us who, for whatever reason, had to be dialing in from home. And I would just like to go on the record, both at thanking everyone for their efforts in that vein, but also recognizing that it is no longer okay or I think effective to assume that we are going to get 100% participation in person, and therefore we need to have a system as a body for running effective meetings that include both people in person and people digitally. There is no reason in this moment in our history that we cannot make that happen, and I would like to go on record as a member of the task force recommending that between now and the next meeting, we take some concrete steps to do that in a way that does not cause frustration for either group of people, the people who are able to be in the room and the people who are not. Thank you.
All right. I don't see any other hands. And I would just say, I agree with Joby that we should have procedures that are understood, but you have to understand that the state of Illinois does not use Zoom, so we are limited by WebEx. We are limited by rooms that are not set up for video conferencing that we may have to use. But I would really love it if all of you would email me with your suggestions, and for the things that you found particularly frustrating. I was particularly frustrated by not seeing a little yellow hand in the box of the person that raised their hand. Just didn't show up, I don't know why. So, thank you all. I, again, would urge you to read the cover memo if you haven't, because it does set forth some of the needs going forward, and we're gonna try and make longer meetings as comfortable as possible, and hopefully we have 2 more meetings, and then we have 2 public hearings. And then we're gonna be drafting a report, so we do have still a lot of work to do.
But I do want to make a pitch for the doodle.
Why don't you, because I don't know doodle.
Okay, so there are 2 public hearings, and we're hoping that every task force member can attend at least one in Chicago, and there's also one in Springfield. So we sent out in the email a doodle poll, so you could just indicate which one or ones you're going to attend, so we make sure A, we have enough people from the task force at each meeting, and B, that we can prepare for who's coming.
Which email did you send it at?
You didn't see a doodle
That was,
poll?
I didn't.
I thought it was in the cover email for the material.
May have been, and I could have
You know
just
what,
missed it.
it's probably in the cover memo.
It's in the
Inside
cover. It is. It's inside the cover memo. I have
so
a
then
hard
I just
copy of
missed the
it.
link in there.
Yeah.
Okay.
Yeah. We can resend it so it's on the top of your inbox.
Yeah, we will resend the doodle.
And if you
Lisa, it will
could
come
send it in
from
the body of
Lisa.
the email, that would actually be more helpful than putting it in the memo.
Yep.
Yes,
Thank
it's gonna,
you.
that email is gonna come from Lisa, cause I don't do doodle. And not because I don't want to, I just have never learned it. So keep a lookout for an email from Lisa on that. And by enough members at each public hearing, it would be great to have 3 or 4. I do not expect you to see all of you in Springfield.
And we'll be doing those on Zoom as well, if you're here and wanna watch, right, aren't we?
Well, yeah,
I mean, or WebEx.
WebEx.
Your motion?
Can I make a quick, can I ask a quick question or make a quick comment before we shut down? This is Chief Davis.
Yeah, is this Chief Mitchell
Yes, ma'am.
or Davis, sorry? Why
Yes,
can't I
ma'am.
get your name? Okay,
Like I said, I've been called worse, so I'm good. Just for, I don't know if we can make this consideration or not, but for those of us who are not downtown folks, I asked that we if we can consider doing 10 to 12. It kind of makes it a little easier if we got to come downtown for a transportation standpoint, but just want to throw that out there. Thank you.
yeah, I mean, we could do meetings at a different time. That's, again, please email me your preference. If we're gonna do a 4-hour meeting, it might behoove us to do it in the afternoon so that people who can travel don't have to come up a night before. Or at least start at 11 instead of 9. Please let me know what your thoughts are on that. And yes, we would have food. Somehow, we would figure out how to get food.
Okay. Is there a motion to adjourn? No?
So
You
moved.
guys wanna stay for another few hours? Thank you. Was that Chief
Yes.
Davis?
Yes, ma'am.
Okay.
A second?
That one we don't have to roll call.
Okay. Meeting's